For pronouncement of judgment, item 1 and 2.
Petitions dismissed.
Adjournment request, if any, from item number 1 to 3.
Please, Lordship. Lordship, I beg to mention item number 2. Lordship, we have taken consent from the other side, Lordship. Seeking for an adjournment.
You are for?
I am for the respondent. Lordship, I am for the applicant.
Mr. Saraf is not here.
Doctor, yes, your Lordship. He has some difficulty to do.
Request is made for adjournment on behalf of the full response. It has not been opposed by the contractor. So we done this in the September. Yes,
Lordship, may I fix a date, Lordship? Next week, Lordship.
September we take a date from the rich.
From item number 4 to 15.
May I please, Your Lordship, in item number 4, Your Lordship, I am respondent number 1, Your Lordship. With the consent of appellant side,
John,
Lordship.
September.
Oblige, Your Lordship.
Yeah, adjournment report.
May I please, Your Lordship, for the item number 6, may I pray for the adjournment? I have taken the consent from the respondent. Item number 6.
Compassionate appointment after 15 years. Why to keep the false hope of the appellant is alive?
Your Lordship, my senior is suffering from a fever.
What he will architect? There is nothing in this matter.
He's suffering from fever.
Next.
Oblige.
From item number 16 to 29, adjournment request. No. Any other request?
Lordship, I'd like to listing for PIL 53 of 23. This is artificial flood condition.
Make a request to the registry will place it before us, will consider.
May it please your Lordship, item number 12 to 21, which are listed in the
Item
series
number
12 to 21.
To 25.
21.
Yes, my Lordship.
It's a connected matter.
Yes, your Lordship.
So
Lordship, the matter may kindly be taken next week.
it's a connected matter. It's not only the single matter. Analogous matters are also listed here. 7 to 25 are the bunch matter. Well, 12 to 21.
Yes, your Lordship.
And this is a connected matter. What about the others? Let the number come.
Daily list for hearing, item 1.
From 7/1/25, we have
My
done.
lord, we have filed the affidavit yesterday, my lord.
Yesterday, it is not on record.
Yes, my lord, yesterday.
Indirect adjournment.
Yesterday we have filed it, my lord.
So, have you gone through the affidavit?
Nothing is there in the affidavit, just throwing one ball from one head to another.
Need not to file any rejoinder to that?
Nothing.
Okay. Okay, then, on 7/1/2025. Time was granted to the council for that. Council for the health department. To file an affidavit regarding the steps required to be taken by the central or the central government on the issue involving the PIL petition. In view of the standard operating procedure issued by the Ministry of Health and Family Welfare, Government of India. Thereafter, on 29/4/2025, thereafter on 3/3/2025 and 29/4/2025, further time was granted to furnish the factual report. Mr. So I submitted the affidavit along with the affidavit explaining the steps taken by the respondent health department. The health department of the government of Assam is already filed. However, the same is not available on record. Learned consider getting for the petitioner is in receipt of the said affidavit. However, I submitted that no counter is required to be filed to that affidavit. In such circumstances, when the service is complete, list this PIL petition for hearing. When
Any date, your lordship, within this week?
after 2 weeks.
Item 3.
Your lordship, I pass any order, I could not proceed.
Okay. It's
Only thing that I can give the earlier judgment passed by this honorable court. He
Which judgment?
prepared. That judgment. This judgment may give some light to your lordship.
Okay.
So 5,000 worker. Revenue for Georgia. Very. नेल्सन का जजमेंट तो आपका जजमेंट तो खराब होगा लाइन बिलो हो जाए कोर्ट ही ठीक रखा होगा तो यहाँ पर एक लाख के एकदम लाइफ को
How this judgment will help you?
No, on the last petition, Lordship, that earlier the judgment.
That was the only reason, because the act was, act was not connected, therefore these notifications they found that are not in consonance with the law. It's altogether different thing.
Pursuant to this judgment, probably this act was enacted.
Yeah,
This act, but the Impugn Act was enacted probably pursuant to this judgment. Accordingly, my contention
at
before
that
this,
time when this judgment was pronounced by the learned single judge, the act was not, it was only a draft. It was not enacted. Later on, it is enacted now.
no, this act, Impugn Act has been enacted.
Now it is enacted.
Now, this act, which I have challenged, this regulatory act, name of this act is defined.
The Assam Inland Waterways Transport Regulatory Authority Act.
Mm.
Now, this is the act which is in force.
The name of this act is Assam Inland Water Transport Regulatory Authority,
That's what, 2018.
18.
Earlier, it was the draft act of
The earlier act was totally different.
Assam Inland Water Transport Department Act,
Mm.
2014.
2000.
That has never been enacted.
Mhm. That act was in the draft stage only.
Yeah.
Mm.
That
But
would
it's
be
a-
challenge that these notifications, when the act is not enacted, these notifications can't be issued, and the learned single judges agreed to that.
Mm.
But here altogether different thing. Now
My
you are
content-
telling-
My contention is only after that judgment, the legislature of Assam enacted this act.
Fine.
And by section 14(2)(k),
Yeah.
that private participation, public-private participation.
14(2)(k).
Mm. Mm. That
So how you are aggrieved by that?
because they will advise the government. Because
Only, advisory jurisdiction. So
And in fact, it should have been delegated to the transport department because they are dealing with the business of ferry business.
here the act is already there. It says
Transport
to
department,
regulate the activities in the inland water transport, to regulate the activities in the water port and terminal service operation, to register vessels operation, so and so. And it simply says, advise to the government on public, promote public, private transportation, outsourcing and effective implementation of the act.
so private participation in public ferry. And public ferry is being carried out by the transport department, by the government of Assam.
These are the policy decisions, Lordship. No violation of any right of the individual persons. So they are working under the transport department, and their rights are no way being infringed upon by this act. So this is on a totally different area. We want to expand, and there should be proper management. Lot of accidents. This act has come out, but because there was a major ferry accident in Majuli, and thereafter a committee was formed, and that committee recommended that a regulatory authority must be in place. So these are part of a different vertical, nothing to do with their individual rights. To challenge and act, they are having a two grounds only, basically, that their fundamental rights has to be increased, which is not the case. And we do not have the competence, lack of jurisdiction. That also is not the case. Whether it is arbitrary, now that Supreme Court is expanding when a law can be set aside. It is neither arbitrary. So they do not have any ground to challenge this act, in my humble submission.
Any law on this point? Nothing.
Lordship, these are basic fundamentals.
Close for order.
Highly obliged, Lordship.
It was
And lastly, the policy decision, it is the domain of the government, Lordship. Unless it is arbitrary or it is in violation of any
Yes.
law enforced.
Yes.
Item 5,
So I appear for the pollution department in this item number 5. Lordship. Next item.
Item number 5.
Lordship, on item number 5, Lordship, we have filed an affidavit in reply, Lord, because the initial affidavit filed, Lordship.
So
Lordship, take it up
it may
next
not
week.
be in the record. So let it come up next Monday, Lordship. Already this case is pending for quite a long time.
Counter is filed on behalf of the respondent number, on behalf of the petitioner in this petition number,
PIN number, Lordship, 32 of 2023.
PIL number 32 of 2000, not on behalf of the petitioner. A additional affidavit is filed on behalf of the private respondent in PIL petition number 32 of 2023. Learned counsel appearing for the petitioner placed some time to file count 2. The same time paid for his granted list of 15. Interim order if any to continue till next week.
Lordship, have already filed, Lord. We've already filed a reply today, Lord.
You have already filed.
Lord, we filed it this morning, Lord.
Within a counter, an additional affidavit is filed on behalf of the private respondent in PIL number 32 of 2023. And a counter is also filed on behalf of the petitioner to the said additional affidavit. However, the said additional affidavit is not available on record just after 2 weeks. Interim order if any to continue till next day.
Give it up. Lord.
Highly obliged.
Register will fix the dates at 2 weeks. They'll fix the date. Yes.
Obliged.
item 7 to 25,
So I am appearing for item number 7, Lordship.
All these matters are connected.
Connected, Lordship, but we have urgency, Lordship.
You have urgency, then
Yes.
argue. What's the problem? We are here only for this. You have urgency, then argue.
Lordship.
How the learned single judge is wrong in concluding that you are not entitled for old pension.
Old pension, but new pension was not,
Because your appointment or whatever the appointment was regularized after 2005 only.
it was not regulation, Lordship. As per the learned single judge, it was adjustment in the government service, Lordship.
Adjustment in the government service, you were holding what post earlier?
Assistant teacher, Lordship. It was created, these posts were created by the Dimahasa Autonomous Council. At Dimahasa Autonomous Council being a 6th schedule area, Lordship, this council has the authority to, Lordship.
What is the finding of the learned single judge in this respect?
At page, Lordship, our portion is at page 236.
236.
Lordship, if I may, Lordship, Lordship, in item number 13, Lordship, we had calculated adjournment stipulation, Lordship.
Madam is showing urgency, all these matters are connected.
Lordship.
If madam will argue, then certainly all these matters will be covered. What else?
Lord.
If she is showing urgency, I have urgency. then we-
Though my lord, this is, with due respect, my lord, though this is common judgment is passed, my lord.
Yes,
But in the judgment itself, there are classification, my lord. All backgrounds.
about the classification.
Yes.
We are concerned about item number 7.
7.
Whatever the matters which are covered by item number 7,
Yes, sir.
that the judgment will govern all those matters. What
Yes,
can we do?
yes, sir.
If the matter have urgency, we'll argue. the matter.
Others, maybe Lordship general area, and my case is only Lordship 6th schedule area.
Whatever it may be,
Service
madam,
condition maybe.
how many writ petitions similar to your case happening, those, all the cases would be governed by that. What can we do?
Okay.
Argue it out.
Lordship, next week then, Lordship. Next week, Lordship.
Why next week? Madam is having urgency.
Now she has agreed, Lordship.
No urgency, then you, while making adjournment, please make it sure
Lord.
that from all the persons of the connected petition, you should obtain this.
I'll make sure.
We are not going to do. Yes, ma'am.
Lordship, we have urgency because Lordship, they.
So then argue it out. Why you are
Lordship,
agreeing to it?
Lordship,
Argue it out.
Lordship, our 236, Lordship, page 236.
Madam, judgment starts in fact from
From-
36.
Lordship. It starts from 143, Lordship. And we are concerned with page 236, the
Teachers appointed in the 6th schedule area, Dima Assault District Council.
Lordship.
Read.
But, the cases of the teachers of the instant category are in WBC number 5409/2020. This is my case, Lordship. And WBC 5895/2021. In these two cases, this court had earlier reserved the judgment on 23/2/2023. However, in the meantime, an additional affidavit in opposition was filed by the District Primary Education Officer Dimasa Haflong on 15/3/2022. Taking into account the state affidavit, this court further heard these matters on 23/3/2023. Before dealing with the facts involved, it would be relevant to take note of that in the fixed schedule areas, more particularly in the Dimasa District Council, the said District Council has two sets of employees working. One category of employees is governed by the service rules of North Kasar Hills Autonomous Council, presently known as Dimasa Autonomous Council, where employees are not entitled for pension and they are known as the normal sector employees. Their salaries are being paid from the revenue earned by the Autonomous Council. The other category of employees are governed by the Assam State Government Service Rules, and they are entitled for pension and other service benefits as declared by the state government from time to time, and they are called district cadre state sector employees. In respect of latter category of employees, their salaries are being paid by the state government from the state exchequer. It is also a practice that when vacancy arises in the state sector, the employees working under the normal sector get an opportunity to apply for the same, and as per the requirement and qualification of the candidates, they are brought within the fold of the state sector. It is an admitted position that the petitioners in both the writ petitions were first appointed as the normal sector employees by the North Kasar Hills Autonomous Council as it was then existed. Subsequent thereto, when the vacancies arose in the state sector, the North Kasar Hills Autonomous Council Dimasa Autonomous Council allowed regularization of the LP school teachers, thereby bringing in them within the fold of state sector by passing appropriate orders. A perusal of the repetition in WBC number 5409/2020 would show that on 25/10/2010 and 28/6/2013, the petitioners herein were serving under non-sanction post normal. Their services was regularized to the government sanction post non-plan cause due to retirement date of the incumbents. In WBC number 5895/2021, the service of the petitioner herein was regularized under the government sanction vacancy due to retirement date of the incumbent. The petitioners in both the writ petitions, therefore, prior to the order dated 25/10/2010 and 28/6/2013 were admittedly not entitled to pension in terms with the rules of 1969. Although in the order it has been mentioned that the services of the petitioners were regularized, but in the true sense, the same cannot be said to be regularization in view of the exposition of the term regularization by the Supreme Court in the case of District Bar Association, Bandipora, Supra. In fact, the petitioners were brought within the fold of government service on the basis of the said order dated 25/10/2010 and 28/6/2013. Under such circumstances, the petitioners cannot claim to be entitled to the pension in terms of the rules of 1969 in view of the mandate of Rule 31 of the rules 1969 and Rule 2A of the said rule. Under such circumstances, this court does not find any merit in the instant repetition for issuing a mandamus as sought for. Lastly, this court would also take up one further contention raised by the learned counsel appearing on behalf of the petitioners. The contention being that the petitioners have rendered service for a long period, and as such, it would be unjust not to take any into consideration of their past services rendered and thereby not grant them the benefit of old pension scheme under Rule 1969. This court finds it apt to take note of the observation of the Supreme Court in the case of Uttar Haryana, wherein the Supreme Court categorically observed that a sentiment and sympathy alone cannot be a ground for taking a different view on what is permissible in law. That's it. And therefore, that's it. Under such circumstances, this court therefore is of the opinion that merely because of the fact that the petitioners in the various categories of research, other than the stipendiary research, have rendered services for a long time before entering the services of the government, that cannot entitle them to the old pension scheme regulated by the rules of 1969. In the backdrop of the above, this court therefore disposed of the instant batch of writ petitions with the following observations and directions. That's our case 240. 240. Roman 6.
Yes.
The teachers who have been brought within the fold of the state sector employees by regulation of their services by the Dimasa Autonomous District Council on or after 1/2/2005 would not get the benefit in terms with the rules of 1969, but they shall be governed by the new pension scheme applicable to the state government employees of the corresponding rank.
What is your
Argument, Lordship, first of all, this new pension scheme was not applicable to the Dimasa Council till 2021, Lordship.
to which pension?
Lordship, new pension scheme was not made applicable to the Dimasa Council.
The learned single judges said that you were the employee in the this sector.
Normal sector, Lordship. This affidavit was
Normal sector employees.
Lordship, this affidavit was filed after hearing. is
Where
complete,
employees are
Lordship.
not entitled for pension and they are known as normal sector employee.
Employee,
You were the normal sector employee
Lordship.
under the Dima also, where no pension was payable.
It was not mentioned in their appointment letters, regulation letter,
There's no
anything,
need. You
Lordship.
just show us that you are entitled for pension from that act or rules. If that is not there, your services are admittedly regularized after 2000, after 2005, in the year 2010 and 13.
Either 2007 to 2013, in between 2007 to 2013.
Okay, even 7, not prior to 2005.
But it was not regulation, Lordship, because their service, initial service was not irregular. It was a regular service under the Dimasa Council. In their affidavit, Lordship.
The learned single judge said you came into the state court only after passing of these orders. Prior to that, you were not in the state court.
Yes, sir.
So what's wrong with that?
Our case is, Lordship, our past service under the Dimasa Autonomous
That
Council
the
may be
learned single
considered
judge has
for
already dealt. What's wrong with that? Why the learned single judges relied upon the Supreme Court judgment?
Lordship, Supreme Court, Lordship. Lordship, can you see our the affidavit filed by the Dimasa Autonomous Council, Lordship? This is this is in page 82. From 81, it starts, Lordship. 82, Lordship, serial number 4.
Serial number 4,
Four.
page
Page 82.
82.
That's page 4, the paragraph 4. That with regard to the statement made in paragraph 2 of the petition, the respondent begs to state that although the petitioners were appointed by the North Central Hills Autonomous Council, but due to paucity of funds in the council, there was hindrance in paying their salaries. But later on, their services were regularized in a phased manner by giving them the government appointment order. Subsequently, with the introduction of the new contribution pension scheme by the government of Assam, employees joining regularized to government sanctioned posts on or after 1/2/2005 are said to be guided by the new contributory pension scheme and are not covered by the Assam Service Pension Rules 1969, and also they are not entitled to a subscription of GPF. We have already received the GPF lottery. Yes. The next lordship, that with regard to the statement made in paragraph 4 of the petition, the deponent begs to state that the total strength of the government sanctioned post of LP school teachers in respect of the Dima Hasao district is 1444. However, North Kasar Hills Autonomous Council was of the opinion that the government sanctioned post of just 1444 LP school teachers are not sufficient to reach all remote areas of hilly terrain district. Keeping in view the position of the sanctioned government post of LP school teachers, the executive committee appointed several unemployed qualified youth as LP school teacher on its own created post, that is non-government sanctioned post. This post were lordship, though non-government, it was sanctioned by the Autonomous Council lordship, and Autonomous Council has the authority to create this post at par with the state government. The said unemployed qualified youths who were appointed by the executive committee of the North Kasar Hills Autonomous Council were paid their monthly salary from the revenue of North Kasar Hills Autonomous Council and categorized them as North Kasar Hills Autonomous Council normal sector LP teachers. However, due to acute financial crisis happens to occur under the normal sector of North Kasar Hills Autonomous Council, and also to overcome the situation, that is payment of salaries to its employees, and with a view to downsizing the numbers of LP school teachers under the council normal school sector, the latter services were regularized to the government sanctioned post if and when fall vacant, post due to retirement, on superannuation or death in harness, etc. by the North Kasar Hills Autonomous Council Authority. As a result of which, some of the unemployed qualified youths who were appointed by the executive committee of the North Kasar Hills Autonomous Council were given government appointment order. Thereafter, only their monthly salaries were paid under the state government fund budget. Subsequently, with the introduction of new contribution pension scheme by the government of Assam, employees joining regularized by the to the state government pension post on or after are said to be guided by the new contribution pension scheme and are not covered by the Assam Service Pension Law 1916. Also, they are not entitled to subscription of CPF. Now, let's say, first of all, it was their sanction post created by the North Kasar Hills Autonomous Council. Therefore, their service were regularized under the regular service under the North Kasar Hills Autonomous Council lordship. And here they have not stated that they were it was regularized. They have stated it was regularized under the government regular post, but it was due to financial difficulties. And learned single judge has stated that it was not regularization in the proper sense of the term, because their initial appointment was not irregular lordship. It was regular service under the Dima Hasao Autonomous Council. Because therefore, learned single judge has said that it was adjusted against government service. So
When it was adjusted since then?
okay.
Earlier, when you were employee of the North Autonomous Council, you were not entitled for any pension.
Lordship, in their affidavit, nowhere it is stated, Lordship.
Nowhere it is pension. Show us from the rules. Yes, you are entitled for pension. Show us the rules of this Autonomous Council that you are the employees of the Autonomous Council are entitled for this pension.
They have not denied it, and
They have not denied it.
service to
Madam,
Lordship.
you have to show us. Because there is a finding of the learned single judge that you are not entitled. These salaries are paid from so where employees are not entitled for pension and they are known as normal sector employees. This is the finding recorded by the learned single judge. Show us that the finding is wrong.
Lordship, in the their affidavit or all their appointments order or any other orders, Lordship, it has nowhere stated that they will be guided.
May not
They-
be stated, but it's a finding recorded by the
Findings,
learned
Lordship, but
single
on
judge.
what basis?
How this finding is wrong. Show us any provision of the law which says that no, the employees of the North Kachar Hill Autonomous Council were also entitled for pensionary benefit. Show us. This is the rule as per this, they are entitled for.
Lordship, with the adjustment with the state government vacancies, Lordship, state government vacancy, with that, they are now government, they are now government employees.
They are now
And
government
therefore,
since
otherwise, they are
since when?
since 2007 to 2013, in between they
Not
were,
prior to 2005.
yes, Lordship. 2005, it is related to lots of new appointments or regulation.
So that
Our
is
case is
your
neither
appointment.
new appointment nor
You
regulation.
came into the state fold for the first time in 2017 to 2013.
2007 to 2013.
13. This new pension scheme was introduced from 1/1/2005.
2005.
So how, when you are not in the state,
And
fold,
this new
you
pension
are
scheme,
not in the state fold in the year 2005, how you are claiming
After
benefit of the
2000
pension in the old scheme, pension
after
scheme?
2007, we are under government servant.
Obviously, there is
Therefore,
no doubt about it.
the service they have rendered under the autonomous council lordship. Our case is that the service they have rendered under the autonomous council, this will be considered for.
Where is the law on this one? Show us any law, any provision of the law, any judgment.
And also, lordship, since new pension scheme was not made applicable 2021 lordship in the Dimasa Autonomous Council, because
Madam, you forget about it. You came into the state fold in the year 2007. Then you have nothing to do with the Dima Assault Council.
lordship,
Came in this, you entered into the state fold in the year 2007 to 2013. Forget about Dima Assault Council.
we are for considering our past service. This is lordship.
This is what your case is.
Lordship.
So how the learned single judges denying considering your past services committed any illegality?
Because it was as per Honorable Single Judge Lordship, they were in a non-pensionable service under the Mass Autonomous Council, and therefore it cannot be considered.
That is how it is wrong.
Because Lordship, in the petition, the respondent nowhere stated that it was a non-pensionable establishment.
Okay.
So
Yes,
it was
nowhere
not.
stated,
It was
but-
not. It was
But
not their
you
case,
just show
Lordship.
us any provision of law which
Lordship.
says that yes, it's a pensionable service. Show us any law. This finding recorded by the learned single judge is wrong, then we'll interfere into it.
Lordship. It's fine. Lordship, because the Mahasa may be directed to produce the service rule lordship, because we have not received the service rule.
Madam, you have to prove your case. You are,
Lordship. No, we have not received the service rule lordship. We tried to get it lordship, but it is not available.
Madam, you have to show this finding recorded by the learned single judge is wrong. You have to show it.
Lordship. Only point is this lordship that the no, it was non-pensionable establishment. That only on this ground lordship it was rejected.
This is what the learned single judge said, how this finding of the learned single judge is wrong.
Because there is no lordship, nothing on the record that it is not non-pensionable.
Yes. Yes, Mr.
Page 57 of the records, ma'am.
57.
57.
Yes.
The North Kachar Hills Autonomous Council is pleased to allow regularization of the senior-most LP teachers serving under non-sanctioned post to the government sanctioned post. So the entry of these people, at least, it came in 2013 to government department. They were under non-sanctioned. Once they enter service in the year 2013, and there is nothing to indicate that even the proper selection was there. So simply they were shown working somewhere and they were regularized in 2013 to government sanctioned post. No procedure followed, nothing done, senior most posts. In this way, madam, they have come in 2013 or 2010, after the new pension scheme came into. Hmm. 13 and at page 60, they have come in 2010. The entry into the government police in 2010 and 13, much after 2005. In fact, at page 237, Learned Single Judge has gone ahead to hold that it was not a selection, and it was not a regularization per se. It wasn't something to be that way. It couldn't say anything with that. Doing with that. The activity visa. Page 91. And it's liability. No contributed. Page 86. Thank you. Thank you. Deputy part and leave salary part. Here, leave salary, deputy, anything. There's no thing. For, no, normal. इसमें कुछ देना कि discussion इसमें कुछ deputy and deputy. Page 79. Deputy and the. Hmm? Hmm. Hmm.
Well,
I am told that for the normal sector, there is no scheme of pension being paid to any of the teachers. And if Lordship has page 79 for a moment, the representation made by her,
29.
79, the last paragraph.
Yes.
Gratuity, leave salary, etc. Now, they are entitled to gratuity, they are entitled to earned leave salary and GPF, etc. But there is no pension scheme for the normal teachers at any point of time, normal sector teachers.
This is not her representation. This is by Vidhan Chatra Mahanta.
This is annexure to the read petition. So I presume that this is one of the representations made by some petitioner. It's 10 others, so perhaps we'll move for one of them.
Connection to the
Yes, petition number 2. Vidhan Chandra Mohanto is petition number 2.
here in this
Yes.
number 7 is petitioner number
2 is the in the writ appeal
get
is
retired on 3/12. I have retired.
2008.
Teaching up at my-
And even at page 80, the next person says, release my gratuity and leave salary. It was well understood that normal sector persons did
My
not,
pensionary benefits such as my gratuity, leave, salary, etc.
etc. And then at page 80, Lordship will find it is gratuity and leave salary. So normal sector employees, I am told, were not entitled to any pension, but the other part they were entitled to leave salary, earned leave salary, etc. So those were the representations made.
Close for orders.
Lordship, one thing. I have instruction that those normal sector employees who were Lordship regularized before 2005, Lordship, they were receiving pension.
Actually,
But they,
this is the pension. What's the problem?
Lordship, they are also from the non pensionable
But
establishment.
they came into
Their
the
service
state,
conditions are same.
they
Lordship.
came into the state code prior to 2005.
Yes, 2005, but our also cannot be considered as regularization lordship. It is absorption or adjustment, whatever may be lordship. Therefore, our past service may be considered lordship.
Close for order.
This should govern only while the present rate appeal.
Yeah.
This order should govern only the present rate appeal, the others.
Present rate appeal, obviously. Whatever
Yes,
it
if
may
we are
be,
concerned-
the consequence will follow.
Lordship.
Obliged.
Lordship.
Adjournment picnic हो पता नहीं। इसमें adjournment picnic है, बोलते हैं।
8 to 11. Item 8 to 11.
Item number 8 to 11,
My lord, my item is 7, my lord. It is different matter, my lord.
your item number is
11, my lord.
11, 8, number 8. Who is appearing for the number 8?
8, 9, 10.
I am for the 8, 9, 10 votes.
They come,
Our matter is similar, Lordship.
similar, then adopt. as
Another date will be fixed.
Another date may be fixed, Lordship.
Short date.
No,
please.
you have not moved any application for adjournment. Will hear.
Lordship, there's some difficulty on our part, also finance department regarding these matters, Lordship.
Huh?
Lordship, I'm appearing for the finance, there's some difficulty, Lordship, the arguing council is not available for these matters, Lordship. I'll seek a short accommodation.
Why you have not moved an adjournment slip?
No, Lordship, here,
Why you have not moved that then? If you are having some difficulty, you are having a difficulty, why you have not moved this application?
Lordship. There's a mistake on,
No, we are not going to adjourn, whatever it,
Lordship, only for,
you're not going to adjourn. Either you move an application, otherwise we are not going to.
Lordship, here,
yeah.
we have made a mistake, Lordship.
You have made a mistake, then suffer. Every mistake has to pay a price. That's all.
Lordship, only,
No, fine. Which category of teachers you are?
My lord, we are, Lordship, appointed by the managing committee, Lordship.
Managing committee of?
Managing committee of the concerned schools, Lordship. When
concerned
that were at the venture stage, Lord.
Yeah.
But subsequently, Lordship, in the year 1992-89, Lordship, all the schools were provincialized. But
Right.
our services were not provincialized, but we were allowed to continue service, Lordship. And ultimately, Lordship, after the Jivan Chandra's Deka's judgment, Lordship, that judgment was in the year 2003, Lordship.
Which judgment?
Judgment was, Lordship, in the year 2003.
First of
Lord.
all, you just show this impugned judgment in your
No,
case.
no, there are no impediment. We are writ petition. My 8, 9, 10 are writ petitions, Lordship, because we are,
Read petition?
these are writ petitions, Lord. Because, Lordship, similar matter already, Lordship, subsequently dismissed by the Honorable Single Judge, Lordship. That's why, Lordship, my matter, Lordship, tagged along with the writ episode during pendency of my writ petition.
what do you think, yes, everything? It's submitted.
Move to writ petition.
Why this matter is listed before the division bench?
Lordship, because, Lordship, during pendency of these 3 writ petitions, Lordship, in the similar matter, Lordship, subject matter, Lordship, the Honorable Single Judge dismissed, Lordship. So that's why a prayer was made from the government part, Lordship, that this matter may be
Where
taken.
is that prayer and when this order was passed?
Lordship, there was no order, Lordship, reflected, Lordship, but this is automatically tagged, Lordship. No, order 9.
What is your, before the learned single judge in the bunch of petitions?
Lordship, then
Which portion, which are the writ petitions are similar to you, which has been decided by the learned single judge?
Lordship, apparently I have no knowledge, but perhaps Lordship, item number 11, Lordship, as my
Yes,
understanding.
item number 11.
My lord, I am not, clearly, my lord, I am submitting, my lord. Today I am not ready, my lord.
You have to argue. You have not moved any adjournment application. You have to. You just show us which part of the judgment covers your case.
My lord, it is drop teacher, my lord.
Huh? Drop teachers.
Drop teacher, my lord.
Which section of the judgment is discussing about drop teachers?
Drop teacher, my lord, it is starting from page 98 onwards, my lord.
98 onward.
Onwards, my lord, and it is up to 126, my lord.
Judgment order, sir, 98.
98, my lord. In my lord, item number 11, my lord.
Item number 11. 8.
And in the judgment page is, my lord, the 341, my lord.
341.
Yes, my lord. 11 to 11 to
Yes, come to this dropped teachers.
drop teacher, my lord.
Yes, this is item number. Now, read this.
Last, my lord, conclusion, my lord, page, in my lord, memo of appeal, my lord, it is 126, my lord, and page number 369 in the judgment.
369.
In the judgment, my lord. And my lord, appeal, it is running page 126, my lord.
Please, 369 come to 300. Yes.
Conclusion, my lord, it is there. My lord, I may be allowed to state the background of this case, my lord. This petitioner, my lord, were appointed in the, my lord, Benchers school, my lord. Benchers school, my lord, villagers, my lord, established, my lord, on need-basis school, my lord. After, my lord, some seniority, my lord, considering the need, my lord, government taken school. And it is made, my lord, government school like that provincialized school, my lord. But with limited, my lord, post. When, my lord, there are, my lord, excess post, teachers are working there, but available sanction post is not granted to this school, my lord. Then they are called, my lord, drop teacher. They are kept, my lord, waiting for, my lord, further, my lord, chance for provincialization, my lord. Then subsequently, my lord, their chance came, my lord, and they are regularized, my lord. But there is a, my lord, gray area, my lord, helpless area, lordship may, my lord, help them, my lord. I am fairly submitting, my lord. There is a rule came, my lord, in the year 2005, my lord. As per this rule, my lord, those who are, my lord, new entrant, this word, my lord, used in the service rule, my lord, pension rule, those who are new entrant, my lord, from 1 to 2005, my lord, they will get, my lord, new pension. New pension means, my lord, this is contributory pension. Some money they will give, some money, my lord. But our background is different, my lord. Our background is different. Admittedly, my lord, we are regularized after 2005, my lord, when new pension came in force, my lord. But our background is that, my lord, our service was, my lord, counted and accepted from earlier, my lord, from the 90s, my lord. Therefore, my lord, some teachers are already granted, my lord, old pension also, my lord. On the basis of judgment passed by this honorable court, my lord, division bench also, there is one. But learned single.
They were appointed after 2005, but getting pension in old pension scheme.
Old pension, my lord.
After 2005.
Yes, my lord. But here, my lord, learned single judge, my lord.
Their services were regularized after 2005, But they are getting the pension,
Old pension,
old pension.
old pension, my lord.
How the
But
learned-
here, my lord, getting, my lord, old pension on the basis of judgment passed by this honorable court, my lord, from division bench, single bench also. But here in this impugned judgment, my lord, there is a, my lord, change, my lord, taken by the learned single judge in the present impugned judgment there, my lord. Some laws are, my lord, not taken into consideration in earlier rounds of litigation in the division bench and single bench also, my lord. Therefore, my lord, learned single judge is held that, my lord, he lordship is not concurring with those judgment, my lord. Therefore, held that, my lord, they are not entitled
Come to the finding of that.
and my lord, I maybe, my lord, would be convenient, my lord, if another can, even tomorrow also, my lord, I will be ready.
Tomorrow we have another list.
Yes, my lord. Therefore, my
Today's
lord,
list.
because, my lord,
Tomorrow we have another list.
yes, my lord. Of course, because, my lord, I am, my lord,
Not the list will carry it forward tomorrow. We have another list.
my lord, I thought, my lord, our group is taking time, my lord,
Not
therefore.
anything,
This is important matter for me, my lord. Therefore, my lord, just refresh my mind, my lord. Our group is taking time today, my lord. Therefore, I was not, my lord, with all those judgments, my lord. Kindly, my lord, tomorrow, my lord, I have no problem, my lord. Just I will take all those judgments.
we have problem. You don't have any problem, we have problem
With
because
all
we have
respect, my
another
lord.
list tomorrow.
With
This
all
is not
respect,
the
my
list.
lord. I'm
which
sorry,
will
my
be
lord.
carried forward.
It is my misunderstanding, my lord. I thought, my lord, our group is
Your
taking time.
misunderstanding, you have to suffer.
Kindly, my lord. For the interest of justice, my lord.
The rest of this thing, what do you mean by interest of? So the
SGTK
matters,
are constructive, SGTK are all
so
those.
the matters are different, 8 to this,
Yep.
8 to 11, though the matters are listed for hearing,
It
the learned hearing and no adjournment slip was circulated in advance. Learned counsel for the
22. My lord, I have another item, my lord, 22 also, my lord. 11 and my
that is
lord,
also same,
same, my lord. I am representing, my lord.
the same controversy,
Same, my lord. This is same group, my lord. 11 and
8,
22.
9, 10, 11 or 22 colleagues. So, circulated in advance. And today the learned counsel for the petitioner has submitted that he has not prepared the matter and therefore matter may be adjourned. It is very unfortunate that these matters are listed for hearing in many occasions, but on one or other excuse, the petitioner has sought adjournment. So, taking into consideration the above fact, these petitions are this 11 number is writ appeal.
Readable, my lord. My 22, 11 and 22, my lord, I am representing, my lord.
No, you are writ appeal,
Yeah, readable, my lord.
and these are the writ petitions.
Writ petition, my lord. Because, my lord, may I clarify, my lord? After this judgment, impugned judgment, my lord, some writ petitions are also listed before the honorable single judge. Then it was, my lord, advised that, my lord, yes, my lord.
The petitioners submitted that they have not prepared the matter. It's very unfortunate. So these matters were listed for hearing in many occasions, but every time, one or the disputes, the matters are being adjourned. Taking into consideration the above fact that the counsel for the petitioners are not interested in argue the matter, these matters are adjourned. Sine die can be sine die and be listed only when appropriate application is preferred on behalf of the counsel appearing for the writ petitioners and applicants. Keep it in due course sine die. Whenever you are, it is convenient for you, move an application for listing.
I thought 8 10 are also.
Same, order same SAB में. Same order,
Only due to their lordship, appeal.
same order in all the matters. It's all
Development.
equal to 21, yeah, 22, 23.
Item 23 to 25.
You are for the item number 20,
24, my lord.
24.
My lord.
Who is for the 23?
Well, I am for pay.
You are for 23. 23, yes. Which category of teachers you are?
Drop teacher, my lord.
Top teacher, which the
My lord, dead matter.
Come.
Along with dead matter.
your cases are dealt with by the Leonard single judge at page 409.
Well, item number 23, my lord.
23.
Well, this matter may listed along with the my lord, earlier group, man. That has been item.
Have you moved any adjournments late?
My lord, since
What
I
do you
wa-
mean by since?
I came to know, my lord, that the matter will be adjourned today, my lord.
You
That's why,
came to know from whom?
my lord, the
You have
council,
not asked anybody that we are going to adjourn the matter.
my lord.
इसमें सेम ऑर्डर कर देना पहले और उन्हीं के साथ ही करो साइन इट adjourn sign it.
How like, sir?
Item number 24.
May it please the doctor. Well, in this case, the learned single judge has dismissed my petition on the ground, that my lord, my service was regularized after 2005.
Your case, you belong to which category, sir?
My lord, I was initially appointed on ad hoc basis, my
No,
lord.
no. The Leonard single judges separated the cases by creating the categories, na?
My lord, my case is not within the, my lord, Purnima Hore. My
Right.
case has been disposed of on a by a different order at case 69, my lord.
Page 69.
My
Read.
lord.
Page 69.
Yes.
Yes, read the order.
My lord. From paragraph 2, my lord, I'm reading. The case of the petitioners herein is that the petitioner number 1 was appointed by the District Elementary Education Officer, Kamrup 171/1994, and the petitioner number 2 was also appointed by the District Elementary Education Officer, Kamrup 126/11/1993. Thereupon, the petitioners joined their respective schools and got their salaries. Subsequent to 1995, the petitioners have not received their salaries. Subsequent thereto, on the basis of a report submitted under the chairmanship of it's a S. Manoharan IAS, which is commonly known as Manoharan Committee. It was found that the petitioners were appointed in access to their sanction post. The government of Assam thereafter took a decision to regularize the services of those teachers who were appointed access to the sanction post. The services of the petitioners herein also regularized by an order dated 11/8/2005 against the vacant post. Subsequent to the order dated 11/8/2005 issued by the Director of Elementary Education, the District Elementary Education Officer, Kamrup, have issued orders dated 28/2005 and 29/2005 respectively in continuation to their orders dated 11/8/2005. The case of the petitioners here is that
What we are asking that my case is not decided on the basis of Purnima
Yes,
Hore.
on the basis
So
of
you have to assail the findings of the Purnima Hore then. You have to assail the findings of the Purnima Hore.
my lord,
in
That-
respect of
My case-
these teachers, access teachers,
My case is that, my lord, the
your
petitioner
case is that
services of the
what the
appellant.
learned single judges held in Purnima Hore in respect of the access teachers.
Yes.
And how that finding is wrong.
My
Your
lord,
case may be, your case may be, whatever it may be.
this issue has already been decided by this honorable court, my lord, in the, my lord, 3 different cases, wherein this honorable court held that prior to the amendment of, my lord, 1969 rules,
Yeah.
the circular by which the, my lord, vested right was taken away, that cannot be acted upon. Because, my lord, 2005 amendment, the amendment was, my lord, effective on 14 July 2011.
This in Purnima Hore, the cases of the access teachers are dealt with by the learned single judge from which para? In Purnima Hore judgment,
My lord.
you are not aware. Okay, we'll see.
Let me take up the matter in the next week, my lord. I will
No,
go through the.
no. Why you have not moved any adjournment?
My lord,
Why you not moved any adjournment?
I was on a different line. I prepared my argument my lord, on a different line, my lord. My case is that, my
Sir,
lord,
it's very, the learned single judges decided your case covering it from Purnima Hore and you are not aware of the Purnima Hore judgment.
Item 7.
Well,
Item 7.
You have started arguing. Too much.
That's it, but I did it.
Yes,
Malat, I have given that Malat, the amendment which was effected, Malat, on Malat.
Yeah.
Amendment of the 1969 rules. That was on 14th of July 2011.
Yeah.
And the 2005 Malat scheme came into effect from 1/2/2005 by giving retrospective effect of the amendment. So Malat, this honorable court Malat, in the case I have given to lordship, wherein in the case of Dilip Kumar Medhi,
yes,
Dilip Kumar Medhi, paragraph 11, 9, my lord, paragraph 9. The facts are narrated. Paragraph 9. Counsel for the petitioner submits that though the services of the petitioners to regularize as teacher on 4/6/2008, their past services prior to regularization have to be counted for the purpose of benefit of an retirement due. And my lord, the state submission is paragraph 13. Some substance of respondents' counsel submission that the new defined pension scheme 2009 having come into force with effect from 1/2/2005, the petitioners could not be covered by the new pension scheme as the services of the petitioners were regularized on 4/6/2008. That was the extent of the state, my lord. Now, my lord, in earlier round of litigation, while the government, my lord, undertook to regularize the services at page, my lord, paragraph 17.
that is, this, Dilip Kumar Medhi.
Yes.
The case of the drop teachers, not of access teachers.
My
So how this case will help you, sir? Because you are the access teacher, not drop teacher.
my lord,
It falls within the category of access teachers, not in the category of all the.
it will be applicable, my lord.
Right.
Paragraph 17, my lord.
Yes.
I have heard the counsel for the parties. I found that the stand of the state government has been reflected in paragraph 4 of the judgment and order dated so and so, passed in so and so, which is as follows. Furthermore, in the affidavit filed with the state, while stating that the regulation when made would be prospective, has agreed to give the benefit of previous services rendered for the purpose of pension and retirement due. And my lord, paragraph 19. In view of the fact that the judgment and order dated 01/09/2003 has attained finality, and as it has been directed in the direction number 6, that the appointment would be prospective but will carry the benefit of past services for the purpose of computation of pensionary benefit, I find that the petitioner's service should be counted as per the.
Here in your case also, this concession is given by the state,
My lord.
given,
In my case, my lord,
Yeah.
no.
Then?
No. My lord, in the review petition, against this judgment, my lord, state preferred a review.
Yeah.
In the review petition, my lord, the law has been, my lord, discussed by the honorable judge, my lord. Paragraph 3, the facts, my lord.
Yes.
Mr. K.P. Pathak, Learned Counsel for the review petitioner, submit that the review has become necessary in view of the fact that while the petitioner's service had been regularized on 4/6/2008, the new defined contributory pension scheme had come into force with effect from 1/2/2005 in terms of the letter dated 25/1/2005 issued by the Commissioner Secretary to the Government of Assam Finance Department and the Office Memorandum dated 6/10/2009 issued by the Government of Assam Finance Budget Department. He also submits that the state respondents can make a law with retrospective effect, and the same would be applicable unless it affects the vested rights already accrued. Accordingly, the Assam Services Pension Rules 1969 was amended on 14/7/2011 by the Assam Services Pension Amendment Rules 2011, which was given retrospective effect from 1/2/2005. Now, paragraph 7, my lord. This court has no quarrel that the proposition that legislature and the competent authority under Article 309 of the Constitution of India have the power to make laws retrospective effect. However, the power cannot be used to deprive the petitioners of their right to be governed by the 1969 rules. The letter dated 25/1/2005 issued by the Commissioner and Secretary to the Government of Assam Finance Department states that the government servant joining the service of the state government on or after 1/2/2005 shall not be governed by the existing Assam Services Pension Rules 1969 and orders issued thereunder from time to time. So far as their pension and other retirement benefits are concerned, they will be governed by the new set of pension rules which are being formulated in the line with the contributory pension scheme announced by the Government of India recently. The office memorandum dated 6/10/2009 issued by the Government of Assam Finance Budget Department provides that the salient features of the new defined contribution pension scheme and also states that same would be applicable to all the new entrants joining the state government service on regular basis against vacant sanction post on or after 1/2/2005. In the present case, the petitioners' service have been regularized on 4/6/2008. The petitioners became regular government servant on 4/6/2008, and as the 1969 rules was in force at that relevant point of time, the executive instruction issued could not have overridden the statutory law. As such, the court had accordingly directed the petitioners would be governed by 1969 rules and not by the defined contribution pension scheme, which came into force only by law by amendment of the 1969 rules in the year 2011.
That's all.
Well, this judgment has also been followed in another case, my lord, that is Sukumar Sarkar.
Yeah.
Sukumar Sarkar, my lord. Because, my lord, against the review petition and the earlier review petition, my lord, no appeal was preferred by the
It is
state.
pending.
My lord, we'll have to wait for the outcome of the appeal, my lord.
The appeal is pending.
Now, in this case, my lord, it is
The appeal is pending.
in the case of
Sorry,
Sukumar
Day
Sarkar.
before yesterday or yesterday it was this.
It was appeal petition. Dilip Kumar Mehdi.
Yes, Dilip Kumar Mehdi appeal is pending.
Appeal is pending.
Dilip Kumar
He
Mehdi.
is not aware.
We'll have to wait for the outcome of the appeal, my lord.
No, we'll pass an order that will govern that appeal. Don't you worry.
My lord, in the case of Sukumar Sarkar, the knowledge single judge, my lord, also followed the judgment.
Yes, sir. That's all.
Paragraph 7, in paragraph 7, it is said, it is accordingly submitted at the bar that the appropriate judgment dated 28/4/2015 has not been challenged in any higher forum and has attained finally.
Big judgment, Sanjay Kumar Mehdi.
Yes, my lord.
That is wrong of the.
But that is why, I was under the impression that that is not challenged. My lord, in this case, my lord, the honorable single judge has held that, my lord, the persons whose services were regularized prior to, my lord, the amendment, they are entitled to the benefit of 1969 rule. And the service of the petitioner appellant herein, my lord, he was initially appointed on 26/11/1993, and his service was regularized on, my lord, 28/2005. GPF account was also allotted in his name, my lord, on 13/2008. But by improved communication at, well, page 40, that is 14/2011, it was directed to stop the, my lord, GPF account, and he was directed to contribute in the new pension scheme. That is why he approached this honorable court. Initially, my lord, he was given the benefit of 1969 rules, asking him to,
Close for orders.
my lord.
Close for orders. This item number कौन सा था? 24.
Oblige, my lord.
Yes.
May I please, Lordship? 25, Lordship.
Item 25.
In this matter, the petitioner is challenging the constitutional virus of the section 82 and 85 of the Assam Provincial Election Act. Therefore, this matter may be segregated from this series.
What they have challenged?
They have challenged section 82 and 85 of the Assam Education Provincialization of Services of Teachers and Reorganization of
8.85.
Lordship. Lordship.
2017 provincialization,
2007.
2017.
provincialization.
That division bench judgment is not,
That this part of the act was not decided.
this part of the act.
This has been kept separate, madam. There other sections were decided. 8.2 was not decided then.
82 and 85.
8.2 and 8.1.
Once the validity of the whole act is upheld,
Hold up. Yes.
the
That,
validity of the whole act is upheld.
then it
Even though if it is challenged, this specific provision was not under challenge or not, that's altogether different thing.
otherwise the entire validity has been upheld.
The act
More or
of
less.
2017 has already been
Okay.
declared as constitutionally valid. You can't have this in this manner that in one petition, though the act is held to be constitutional, then another provision, it is unconstitutional. How can it be, sir? Whole act is constitutional. Okay, it's part of 20 of that. Provisions of 2017. Go into act of challenge. Which as per challenge, however, please notice that the validity of act of 2017 has already been upheld by the division bench of this court in
I'm giving the number.
Matlu Khan, Mohar
Mohar Ali Sheikh.
Ali Sheikh. So and so reported in so and so. Then it's possible for the place sometime. You the Mohar. You the matter. Please notice that the controversy involved in this petition is distinct from the connected writ petitions and writ appeals. Therefore, this writ petition be detached from the connected writ petitions and writ appeals and this for hearing up to 2 weeks.
Oblige.
12 to 21. Adjournment.
Which one? To 21 then it was supported adjourn.
Yes.
12 to 21. Yes. Yes.
Item 26 and 26.
In this case, I'm appearing for the appellants. On 15th, my lord, respondent number 8 has filed an interlocutory application that has been numbered but not tagged with the record, my lord.
When interlocutory application respondent number 8.
Respondent number 8 has filed, my lord.
Yes, sir.
It has been already numbered.
What interlocutory application?
My lord, they want, my lord, in the meantime, during the pendency, appellant number 1 has been promoted to the post of ES. The respondent number 8 has prayed for by that IA, has prayed for stay of that order. That IA is yet to be.
It's a hearing, how this IA can be moved?
Well, they have filed, my lord. Respondent number
When
8
they have filed this.
on 15th of May, my lord.
So why you have not moved an adjournment slip for that things, I mean.
No, I was under the impression that it was already numbered, so it might have come in the supplementary list. It happens, my lord, whenever it is numbered. So that was, I was under that impression, my lord.
Yeah.
But it will come in the next week, my lord.
September.
Item 27.
May I please, Your Lordship? Lordship, this appeal is against the order dated 12/12/2023 that Lordship will find at page 99. Prior to coming to the order, Lordship, the brief facts of the case is that the lead appellant was appointed as graduate teacher in the year 2013. And thereafter, Lordship, he was allowed to hold the charge of in charge headmaster of the high school in the year 2022. Being eligible for the post of headmaster in terms of the Rule 14(2)(a) of the Assam Secondary Education Rules 2018. The requirement is graduate and BT BA. Now, so far the respondent number 4 is concerned, his school was provincialized in the year 2013, and the effect of provincialization is given on 1/1/2013. Now, thereafter the the school where the respondent was working, his school has been amalgamated with the petitioner school. That was done on 17/6/2023. Now, thereafter, the director issued an impugn order in the month of August 2023, whereby my insertion order has been cancelled and the respondent number 4 was allowed to hold the charge.
Who is the senior?
Lordship, as per these rules, I am the senior most lordship. Because Rule 24 of the 2018 rule, it says it determines the seniority. If somebody is come from another school to the present school, then his seniority will be counted from the date of joining in that present school.
He has not come from another school. School
Yes,
has been
merger also,
amalgamated.
transfer or otherwise. This otherwise,
Amalgamation, you means otherwise, amalgamation?
yes,
Otherwise.
otherwise, lordship.
That is not it.
It is their lordship. And the more important thing is that the respondent number 4 is not having the requisite qualification of BT and BA. So agreed by that impugn order of the director, I assailed and filed this writ petition. Now, accordingly, writ petition was dismissed. That lordship, the learned single judge held that since the respondent number 4 is a regular headmaster after provincialization, therefore BA qualification is not required. Let's say kindly come to the judgment from paragraph 8. Paragraph 7. Now, in the meantime, what happened also in 2024? The
Yes,
respondent of 4 is retired.
Huh?
The respondent number 4, he retired from service
When?
in April 2024.
So now what remains?
Now, there's an observation that to hold the post of headmaster, the qualification of BT/BA is not essential.
You decide it in an appropriate case when this he has already been retired. What remains in this?
Because of this, that apprehension.
What apprehension?
The lordship kindly come to the page
Nothing.
103.
He has already retired.
Yes, yes.
Okay, we'll decide it.
paragraph-
In appropriate case, whenever it is raised, we'll decide it. Appropriate.
Because the honorable court make an observation that lordship is the respondent number 4.
Okay, if that observation is not correct, we'll deal with it in appropriate case. Once he is retired for all practical purposes, why should we go into work?
So for a moment, kindly see the paragraph 17 of in the page number 106.
Nothing like now. These are the facts you should have mentioned earlier. This repeat is referred by the appellant being agreed with the order dated 12/12/2020, judgment dated 12/12/2023, passed by the learned single judge in writ petition number 4657/2023. Full stop. The respondent, the petitioner, has preferred the said writ, the appellant has preferred the said writ petition challenging the order dated 5/8/2023 issued by the Director of the Secondary Education Assam, by which the temporary appointment of the appellant as in charge headmaster of Tamor Gaon Tribal High School in the district of Lakhimpur was altered, and the respondent number 4 in the writ petition as well as in this writ appeal was allowed to hold the charge of the post of headmaster of the said school. The counsel for the appellant has submitted that after passing of the order dated 12/12/2023, the respondent number 4, to whom the charge of the headmaster of the concerned school was given,
No, Lordship, because of
is
the,
superannuated in August.
Lordship, page 80 from this document, page 80, Lordship,
Superannuated in
in the month of April
the month
2024.
of April 2024.
Right.
Full stop. Taking into consideration the fact that the respondent number 4, who was given the charge of the headmaster of the concerned school, has already been retired. We don't, we are not inclined to interfere in the impugned order dated, impugned judgment dated 12/12/2023. However, any question of law raised by the appellant in this writ appeal is kept open to be decided in appropriate case. With these observations, this writ appeal is disposed.
Item 28 to 30.
Lordship, there is one more writ petition. If it can be taken up along with 4040 of 2024, Lordship,
40/40.
of 2024. 4040/2024.
The request of the this writ appeals along with
Writ petition,
writ petition number 4040/2024
2024.
2020
4.
in the month of August 2020.